Fantastic. Well, welcome everyone to the May edition of Sprintlaw's free monthly webinars. This month we'll be covering the topic, one of the ones that we get a lot of questions about from our clients, intellectual property and trademarks, a small business owner's guide. Um, Before we get into the content for today, just to quickly introduce myself and Sprintlaw for those who are not already clients. I'm Alex, I'm the co-founder of Sprintlaw. We're an online law firm really designed to make legal services accessible, easy, affordable for startups and small businesses. Unlike traditional firms that charge by the hour, everything Sprintlaw does is fixed fee. We'll always give you an upfront quote. We work in pretty much all areas of business law, from IP that we're talking about today through to employment, privacy, contracts, setting up your company, financing, consumer law, whatever you need, we generally can help. We have an optional subscription membership. About 90% of our clients sign up to it. It gives you access to our actually fairly new platform where you can make some of your own docs, access a bunch of tools like e-signatures and so on. You get credits if you're a member to spend on human legal advice when you need it. And we also have more and more AI tools in there for you to get some instant answers to questions. So for those who are not already members, I'd encourage you to consider signing up. And there is a free tier as well. If you just want to play around and check it out, you can find the link on our website. We've been around for about 8 years. We have a bit over 8,000 clients. Lots of them are happy, lots of positive reviews, and a growing team in Australia, the UK, and New Zealand. And if you are gripped by the urge to get some legal help with IP questions at the end of this session, we'll drop a link in the chat and show this QR code again, but you can book a free chat with our team and ask some questions that you might have flowing from this session. So, IP and trademarks. Today we're going to be going through the sort of basics of intellectual property, covering what are the different types of intellectual property. We won't have time to talk about every type of intellectual property, but we'll talk about the sort of three main ones that are applicable to most small organizations. Number one, trademarks. Number two, copyright. And number three, confidential information. Basically explaining what these types of copyright are, how you can protect them in your business, what you need to do, and sort of how they work. As I'm going through, there's a Q&A feature in Zoom. Do feel free to drop questions in, and I'll check as I go. I'll try and leave a little time at the end for some other questions, but also I don't mind answering along the way. I think it can help add some color to the slides as I go through. So do feel free to pop them in as the question pops into your mind. So let's start with the basics. What is intellectual property, and what are we talking about when we use this term IP? There's really sort of five main types of intellectual property that are worth being aware of if you're running a business. And intellectual property itself refers to really intangible property of your business that is important and potentially worth owning. And it's not physical things like computers, laptops. It's in more of the world of ideas, concepts, and things that may only exist digitally. These things are all in the realm of intellectual as opposed to physical property. So we've got trademarks, which we'll kind of cover. These protect, your brand name, your, logos, other aspects of your organization's brand. We've got copyright. This protects creative works, written works, musical works, artistic works. In a business context, that may be, blog posts, designs, marketing videos, those sorts of things. Confidential information, strictly speaking, many lawyers would say confidential information is not really a form of property in a legal sense, but I like to include it in this bucket because it is also in this sort of world of intangible concepts. If your business has some confidential strategies, processes, systems, or other secret sauce, if you will, that's another thing that we're going to talk about in terms of how to protect. Designs, there is the concept in law of a registered design. This is fairly specific to things like furniture types or product designs. The shape of a Coke bottle is famously a design that can be registered. So not that applicable unless you're creating physical products and have intangible designs for them. But that is a form of intellectual property. And then we have patents or patents, depending on whether you're English or American. These are reserved for inventions They are, things like a new pharmaceutical formula. The COVID vaccine, for example, would be patentable. Um, uh, Big technology leaps, robotic inventions, or things like that. And a common misconception is that people, that you can patent your business name or your business model. It's actually a very high threshold for getting something patented, and really for things that are pushing forward human knowledge, have never been published in any academic journal anywhere. So often not that relevant to small businesses, except the portion of small businesses that kind of know that they uh, are being an inventor, if that makes sense. So this is the kind of universe of IP, and as I said, we'll focus on the three on the left for today's session. Beginning with trademarks. So, trademarks for pretty much every startup, small business, this should be towards the top of your to-do list to think about, should I get a trademark for my business? So, as I said earlier, a trademark is really about protecting your business's brand, but it's more than just the brand. It's really about protecting the identity of your business. And it's a protection you can get that's going to help differentiate you and what you do from your competitors. Now, the most common types of trademark you see are a word trademark and a logo trademark. We've got in the top right corner Sprintlaw's logo and our little S thing, S shape that we have on top. So Sprintlaw has two trademarks for this. We've got a word mark for the word Sprintlaw, and we have a logo trademark for this little S shape. But it doesn't just have to be a word or logo. You can also trademark colors. You can trademark phrases. Nike, for example, just do it. Sprintlaw has business legals made simple. You can trademark shapes, movements, aspects of packaging. Some of these things are more rare. We've got a list of examples here and some on the next slide. There are many different aspects of your identity you can trademark. For most of our clients, they're doing the word and the logo. Some don't even do the logo if their logo. Our logo is quite different to the word, so we want to protect it separately. But if your logo is just the word, you might not bother with the logo in addition to the word. Some of our clients will do the phrase, but not that many do, the color, the smell, and all that other kind of stuff. So there is a large variety of things, but for many people, you want to be thinking about just those main two. Can I get a word mark or a logo mark? Once you own a trademark for these things, you have the exclusive right to use that logo, that word, that phrase for 10 years in your industry, or class as they call it in trademark. So Sprintlaw has a trademark for the word Sprintlaw and that little S shape in class 45, which is the legal class. That means no one else in the legal industry can use the word Sprintlaw to promote their goods, services, business, nor can they use anything that is that S shape. Not only can they not use those exact things, they can't use things that are deceptively similar to it. So Sprint Lawyer, Sprint Legal, potentially even Fast Law, things that might confuse the average person into thinking that their brand is actually the same as our brand. So it's quite a strong protection, and you can see why it's a very important protection. If you're building a business and you're investing time, energy, money in growing the brand, getting known for the brand, you've got a beautiful logo design, customers getting to know your brand, you want to make sure that you own it. Other people can't trade off it. And for many businesses, you want to make sure that someone else doesn't own it already, because you might not have picked up, but someone might already have the trademark for what you're doing, and you might it could cause trouble down the line. So you can start to see why this thing is pretty important. But we'll flesh that out a little more on the coming slides. So again, here is just a bit of a sense of different things that are trademarked. Cadbury's got its letter C trademarked. Eclipse Gum has the number 5. We've got the word mark for Nike, the phrase "just do it." There are sound marks, smell marks, shape marks. A movement mark, which is quite niche. Lamborghini, for example, when you open the doors of a Lamborghini, they've managed to trademark that movement. But again, there's a lot of different types, but I think for most people, it's really thinking about the word, the logo, and the phrase for your business. And unless you have something special in these other categories, it's really those three that you'd be really thinking about, if that makes sense. Now, a very common misconception is that a business name, which most people register when they set up their business. You know, if you register an ABN for your business, if you're a sole trader, for example, there's this option in Australia with the ABR to register a business name. So, you know, if you are, it says if you're trading or doing business under a name that is different to your own, you must register it as a business name, and it costs something like $30-40 a year. And a lot of people do that. Similarly, if you set up a company, you pick a name for your company. You know, we're called Sprintlaw Pty Ltd. If you've got a company that you're running a business through, you may have some name, Pty Ltd, and you picked that name. Now, when you registered either your business name or company name, it was important that no one else had it. And so you might have thought, oh, I went through that process, I selected my name, I've already got my trademark. It's not the same thing. A trademark is a separate registration. If you're not sure if you've done it, you probably haven't done it. You do it with IP Australia, and it is, and I'll show on one of the coming slides, really the difference between those business names and company names and trademarks. But it is important to mention it's a very different thing. And domain names are another thing as well. So, you know, your .com, your .com.au, your .co, whatever it is, that's its own sort of fourth or third registration, depending on your business model. So you can see on the right, in the example of Nestle, they've got Nestle Australia as their business name. They've got a company called Nestle Group Pty Ltd. They've registered the domain nestle.com.au, and then they've got these trademarks for, you know, Nestle and, you know, Nestle itself, but also their key products, Nancare, Uncle Toby's Oats. So you can start to get a sense, and if you think about your business, you would have a business name that you trade under. You'd have a company name that you use for registration purposes. You would have registered a domain name, and when we're talking about trademarks, it's these protections for not only your name in general, but also your product names. Just to flesh out a little more, what is the actual difference between that business name or company name registration? You know, we've got this table. When you register your business name, which most people would have done, that gives you the legal right to, you know, put it on signs and things. And if you haven't registered it, you can get in trouble for, you know, marketing yourself to the public with a name that's not registered. So you have to register your business name. You don't need a trademark. A trademark is optional. It's just a really good idea for the reasons I already shared, but it's not a legal requirement, and many businesses operate without a trademark, if that makes sense. Now, the business name, you can, you know, legally go out and use the business name as your Instagram name, as your in your email signatures, and you can on your shop front, you can use it to say this is the brand of my business, but you don't have the benefits of a trademark. Once you have a trademark for that brand, that means not only are you using it, you're exclusively allowed to use it, and no one else can use it. So while you can operate with a brand without a trademark, it doesn't have those benefits that you get when it's registered. When you register a business name, you don't own it. It's not your property. It's just a legal requirement to register a name with the government, which you have to do when you set up your organization. Whereas with a trademark, it's yours, it's valuable, it's worth something because it is this exclusive right to your brand, which could be sold. If someone else goes out there and starts using your name to market themselves, if you haven't got a trademark, it's very hard to do anything. If you do have a trademark, you can cease and desist and say, stop using that name, it's mine. Yeah, I think the other kind of rows cover the same sort of points. So just to give an example to bring this to life, you know, Sprintlaw, we registered a business name for Sprintlaw when we first set up the business, and we have Sprintlaw Pty Ltd. Now, we might have thought, oh, no one else is using this name, and because we're the only one with the company name Sprintlaw Pty Ltd, and we're the only one with the business name Sprintlaw. So why do we need a trademark? Because no one could even set up a business anyway using the word Sprintlaw. Well, trademarks are not just about setting up a business. If you think about Nestle, they're a big company. They've got products called Nan Care and Uncle Toby's and so on. Equally, you could imagine that a large law firm sets up a division called Sprintlaw. It's not their business name, it's not their company name, but they're out there with a website marketing, Sprintlaw by large law firm. If all we had was the business name, we couldn't do anything. They haven't started using our business name, but they have started using our brand name. And so when we have a trademark, we could say, well, no, sorry, you can't do this. You're infringing our trademark for the word Sprintlaw. We're the only ones in this whole industry that can use this word or phrase, Sprintlaw. So you can start to see, they're different things, this registered business name and the trademark. The trademark is really for the brand, regardless as to whether someone's using it as a business, as a product, as a service line, in whatever way, you get that really strong and broad protection, whereas the business name is just a legal requirement, if that makes sense. This is a slide from IP Australia's website, just helping to establish some of the costs and risks of not getting a trademark. Some of these numbers are probably a little high because they're based on US surveys and global studies. But, I think just to think about if you don't get a trademark, what happens? Well, if someone else gets it and then sends you a cease and desist, you might have to rebrand. That could cost quite a lot of money. It's very common. If you are sued, you could be sued for quite a lot of money for using someone else's trademark. Could be a business-ending moment, and it might be hard for you to expand your business if you want to take it to other places if you don't have security over the brand. So we sadly do see, probably the number one legal issue we see with smaller businesses is to do with trademarks. Number two would be fallouts between business partners and so on, but really number one is trademarks, where businesses have set up a brand, set up a website, started trading, have never actually gone and checked whether someone else has the trademark or not. And, either they discover at some point they can't use that name and slap their hands to their heads and say, I wish I'd known this and saved the money early on. Or in, worst cases, they're growing, and while they're small, they don't hear from anyone. But as they start to do well, one day they get a cease and desist saying, we're going to sue you. And some of them do get sued, and many of them, even if they don't get sued, have to shut down and change their brand name. And you can imagine if it's all over your signage, your domain name, everything, it's a really big deal to rebrand. So you want to get it right. And as lawyers, we often do things in the ideal legal order. So when we set up Sprintlaw, number one thing we did was trademark. It was company set up and then trademark. So that gives you a sense as to where it should sit on your to-do list. If you haven't done it yet, you can do it at any time. It's not that you have to do it at the beginning, and hopefully you can get through without that many issues. We'll talk a bit about the process. But for those that don't have one, I really would encourage you to put it to the top of the to-do list, because it is a pretty important thing to make sure that you secure. So, and I'm seeing a few questions come through about trademarks. I might just finish a couple of slides and answer them because it will help with some of the questions that have come through. So when you're registering a trademark, I mentioned earlier, you got to work out what it is that you're trademarking. Is it your name? Is it your logo? Is it a product name? Is it a phrase? Is it both? If your business just has a business name and no other real brand that it uses, then you're and this is the case for, I'd say, the majority of our clients, you're registering the name as a word mark, and if your logo looks different, you're considering registering the logo. And if you've got a catchphrase, you might be registering that. Now, if your business not only has a brand name, it has some products that you're selling that have their own names. So let's say you're a chili sauce company, and your business is called, the Sydney Chili Sauce Company, and then you have a product called the Super Spicy Chili Dog or something. There's two trademarks there. There's the Sydney Chili Company that you might want to register, and then there's that product name for the Super Spicy Chili Dog, which might be a separate trademark. It may not be your business name, but it's another phrase that you might want to own. So that's what we mean by saying, you're not necessarily just registering your business name. You might register a product name. It's important to mention when you register in a class or an industry. You can register in multiple classes, multiple industries. Sprintlaw is obviously registered in the legal class or industry, and that means if someone else sets up a business in another industry using the same name, that might be okay. So, for example, we own Sprintlaw in legal, but if someone set up um, a restaurant called Sprintlaw that sold coleslaw, terrible name, but uh, an idea nonetheless. And that's, in food, it's got nothing to do with legal. So, we can't go out to them and say, hey, Sprintlaw is too similar to Sprintlaw. Uh, if they're in, quite a different class or industry, we only have the exclusive rights in legal, if that makes sense. So that's important to understand. It is not a broad protection across all industries. It's specific to your industry. And if there's another name or brand out there that you've heard of with the same name as yours or a similar name to yours, if they're in a different enough class or industry, it may not be a problem and you can still get a trademark. So this helps elucidate that a bit further. I mean, on the right side of the screen, we've got this example of Antler, who have a trademark in venture capital. But then there's another company called Antler who do safety helmets, and another company called Antler that do luggage. So all three got through. Antler owned in the finance venture capital space. This Antler owned it in the sort of luggage space, and this Antler owned it in the safety and helmet space. It just means that they're in separate industries, but no one else in, for example, venture capital or probably financing more generally could use a name like Antler. Versus if you're in the same industry, you've got to make sure that, or class, you've got to make sure that your mark is suitably different. So, Cadbury, Snickers, and Darrell Lea have all got trademarks for confectionery or for chocolates. And this means when they registered, Darrell Lea had to be different enough to Cadbury, had to be different enough to Snickers, depending on the order in which they registered. So that hopefully helps explain how these classes work. And another aspect of the rules around trademarks is this concept of distinctiveness. So you can't register a common word. Like in the legal class, I couldn't register the word lawyer, and now no one can use the word lawyer. It's too generic a term. So this is what trademark lawyers spend a lot of time thinking about. There's these concepts of distinctiveness. There's legal rules around them. They're not actually that straightforward. But take the example of Apple. Again, if you're a fruit seller selling fresh fruits, you can't get a trademark for Apple because everyone's selling apples, and the IP authority is going to reject it on the basis that it's an everyday term. It's too generic. It's too broad. On the other hand, if you register it in the technology industry, well, it's quite novel to have a technology company called Apple. And so Apple was able to register a trademark for the word Apple and even their logo, which looks a lot like an apple, in computing, because it wasn't an everyday term or concept in the computing space or technology space to be using Apple. So again, whether something's generic or trademarkable depends on your industry and what you're registering in. But you can, if your name is too broad, too generic, get rejected. And we do see that issue with a lot of clients who have a name that's fairly broad or just descriptive. And IP Australia says, yeah, we can't give you that as a trademark because it's too sort of broad. Finally, I kind of touched on this earlier, but if you haven't got one, when's the right time to apply? Look, you can either apply before you even launch your business. It's going to give you confidence that your name is fine. Like I said, Sprintlaw did it really on day one because we wanted to make sure we had the brand before we built the website and everything else. Or you can, many of our clients aren't sure about the brand and they don't want to spend all the cost trademarking it until they become comfortable with it. So they might wait 6-9 months until they kind of got the brand up and running. And then they go through the trademarking process to sort of lock it in. It can fall down at that stage because, you find out that you need to rebrand, you can't get the trademark. But at least you would know that the name that you're going for is the name that you want. So it's a balancing act, and it is a bit of a decision as to when you do it. My view is the earlier the better in general. And we'll talk a little bit about the timing of the process in a minute on this slide. I'm just going to run through some of the questions that have been asked because there's some good ones here. We've got first question. Hi, I've got a question. My husband wants to name his boat Ambush. Can this be done, or does he need to look at trademarks? Interesting question. It's There's probably a few dimensions to that question. One is, in the uh, sort of vehicle space, is there someone with the trademark Ambush already? Is there a boat brand called Ambush or something similar to Ambush? If there is, slapping that on a boat might cause issues of trademark infringement because they've got the exclusive right to use it. On the other hand, if it's just a name for a boat and he's not out there selling other ambush boats, he's not commercializing it, he might argue that it's not infringing use because he's not trying to monetize it, et cetera, et cetera. That said, it could still be risky because ambush, the boat would say, well, you are, um, uh, you know, um, affecting the reputation of our brand by having it on a boat that we didn't authorize. So, I would, as a matter of precaution, check whether someone else has a trademark for ambush before doing that. But it's probably not extremely risky if it's just for one boat rather than starting a business selling boats called ambush, which I think would be much more risky to do without checking the trademarks. Got a question, can trademark protection travel beyond a National Geographic boundary or is it only within a country? Great question. Trademarking can be done globally, but when you register, you're only running through all these checks that you can get it registered, et cetera, in a particular country and in a particular industry. So the two dimensions of a trademark are what country is it in and what industry is it in. So again, to use the example of Sprintlaw, we got a trademark in Australia in the legal class. We've also got a separate trademark in the UK. We got one in the US. We got one in a couple of other countries that we hope to expand to one day, Canada, a couple of places in Asia as well. Each of them costs money and they have their own process. For example, in the US, it was a lot harder to get a trademark because there was another legal business with a similar name to Sprintlaw, and we had to, fight our way through to show that we were different enough. Whereas in Australia, it was quite straightforward. So yes, the answer is it can travel beyond a particular country, and it's its own process. There is something called the Madrid Protocol, which is an international treaty, which essentially allows Australian businesses to sort of cost effectively upgrade their Australian trademarks to a global protection in specific countries. It costs money. It doesn't automatically get you approval in those countries, but it's a much easier process than having to find lawyers in a bunch of different countries. So Sprintlaw can help for those interested in international trademarks. And again, that's its own decision. Is your business always going to be Australia only, or do you one day hope to expand? And at what point do you decide to go for the trademarks in the other countries? Day one is obviously the best to get it in every place you might go, but it's expensive, and so maybe you take a risk and wait a little bit. And again, in the case of Sprintlaw, we did our major countries on day one: Australia and the UK, and New Zealand. We knew we were going to go there, and then over the years, as we've grown, we've started to do more countries. So that might be how you run it if you have international expansion ambitions. We've got a question here: if we use someone else's trademark, e.g., a similar brand name, who gets sued and who just gets a warning letter? We'll talk a little bit about that in one of the coming slides, but the short answer to that is if your business is using someone else's trademark and it's found to be infringing, it's in the same industry, it's similar enough to warrant it being considered a trademark infringement, usually the person owning the trademark will begin with a warning letter, a cease and desist letter. Please stop doing this or further action will be taken. They don't have to do that. They could sue you straight away, but it's very rare that you don't begin in general with the cease and desist letter. And they'll say, if you don't desist within this amount of time, we're going to take further action. And then they may send you another more final cease and desist and then begin legal action. That's normally how it goes down. But as I said, they could, if they wanted, potentially sue you from day one. And certainly with big companies, you do hear of that happening. They just slap them with a lawsuit straight away. So it can be pretty risky. We got a bunch of great questions coming through here. We recently learned that although we had trademarked our logo, we needed to break it down as we use elements of the logo in our products, sometimes due to space restrictions. Nearly cost us a lot of money. Now covered fully, just mentioning in case anyone does similar and breaks down their logos on products. Yes, so again, I think if you're in the category of business that has a business name but also has product names, um, there can be a bit of a strategy at play in terms of what you choose to trademark. Do you just do one, or do you get additional trademarks for each of your products? And it kind of depends on your use case, how different the product names and designs of their logos are to your main brand. And again, we do a lot of consultations for businesses that might need more than one trademark. So if you are in that category of needing potentially brand marks for more than your business name, definitely worth thinking about getting some legal help. But that's a good comment. A question, do we need to hire a lawyer for a trademark simple brand in a clear category, or can we do it on our own through IP Australia? I'll answer that on the next slide. Related to above question, I presume this is back on the international mark question. Does having a business name registered, owning a website and name already, and having registered the name in another country before provide better protection worldwide? Not 100% sure what you mean, but it sounds like you're asking whether if you haven't yet got a trademark, but you've got everything else in other countries, is that better protection than having nothing? If that's what you mean, then it would potentially be slightly better, but the best protection if you want to go into another country is to make sure you secure the trademarks in each other country. And also, if you need domain names for every country, you want to separately secure those too. Just because you have a trademark doesn't make it super easy to get the domain name as well. As I mentioned before, they're quite separate registrations. Nearly through these great questions. I have a symbol and a phrase. I've registered it both as one logo. Does that give the symbol the same protection, or does it have to be registered separately? So it doesn't give it the same protection. It might give it 80 to 90% of the same protection. It really depends on looking at what it actually looks like for a lawyer to give you an advice on that. Again, if we go back to the example of Sprintlaw's logo here, if we just registered this whole thing with the symbol and Sprintlaw as a trademark, then anyone that has a logo that looks like this would be infringing it. But if we just register this little S shape on its own, it's got broader protection. Because if we've got the whole thing registered and someone uses an S shape but a very different word, they might argue, oh, that looks pretty different to what you guys have registered. But if we have the S shape, it doesn't matter what word they have down here. Maybe it's Agile Law, but it's got the S shape. If we've got that S shape trademarked, it can be broader. So it depends on the actual design, but that's the advantage of separately registering, in our case, this little S shape from the whole logo, if that makes sense. Okay, so we got some questions about cost. I might just keep running through because I will hopefully answer them as we go. So what's the actual process of registering a trademark? For many people, the process is engage some lawyers to handle it for me. And if the process seems too complex to you, or you want some help with it, our team can definitely help. In terms of the cost, for one trademark in one class, we would typically charge about $900, including government fees. IP Australia charges about $300, but the cost goes up if you're registering multiple marks in multiple industries and so on. So that gives you a little bit of a sense of how much it would cost to do it with a lawyer. You can do it for closer to $400 if you do it yourself. IP Australia have something called IP Australia Head Start, which is if you are going to do it yourself, the process I would suggest using. And Sprintlaw do use this process as well for the majority of our clients. It's a slightly faster and simpler process and gets you a quick answer fairly quickly. So the first comment to make on trademarks is this. One of the reasons I'm saying that you want to do this early is because the whole process to actually go from submitting the request to knowing that you own it can take really at least 7 months and sometimes more than 7 months. So it's not like you apply and find out next week. It can be up to 7 months until it's fully locked in. So you can again see why if you're setting up a business or you're running a business, you want to kick off the process early so you know if you own it as soon as possible. So it's a long process. Now, one of the advantages of Head Start is that you get a pretty quickly, within a week, you get a preliminary report, which gives you a good sense as to what's going to happen at the end. It's not confirmed, but IP Australia will either go, this is, not going to go through. We're going to reject it because it's too broad, too descriptive. It's Apple in the Apple industry. They give you a preliminary assessment as to the prospects of success. Uh, or they say, hey, this looks like it's probably going to be fine. And so at least if you use the Head Start process, you find out pretty quickly where you stand. And in most cases, when IP Australia says it's probably going to be fine, it kind of is fine. That said, it's not always fine. And even after IP Australia have said it's okay, what happens is you apply for the trademark. So let's use the example of Sprintlaw. We apply for the trademark for the word Sprintlaw. IP Australia either says, no, that's too similar to something else, or yes, looks like it's fine. If they say it looks like it's fine, then we move to formal application and we wait. And there is an opposition period where anyone who is in the legal industry with any name whatsoever, or otherwise, maybe they are in another industry, they can look at all the pending trademarks and oppose it. They can say, I don't like this. I don't want this on the register. I think it is too similar to my trademark. And if that happens, we have to have an argument with them. There is a process with IP Australia where you can, they will sort of allow you both to submit claims, and they might make a determination, but it can also progress into legal proceedings as well. So it can get messy if someone decides to oppose your trademark. Again, in most cases, when you get the tick from IP Australia, you're likely to get the tick at the end. And again, one of the advantages with working with a lawyer is quite early on in the process, we can at least give you a sense as to whether it's going to be okay or not and help you submit the right kind of application. We can never guarantee that what IP Australia is going to say and that you won't get an opposition. And that's important to recognize. It's not just a box ticking exercise to get a trademark. It is a application process where you try and give yourself the best chances of success. But as I said, if you've got a fairly unique name, it's likely to be not that big a headache, and the Head Start process is certainly designed to be DIY. So again, if people want legal help, Sprintlaw certainly do it. If people want to have a crack at doing it themselves, if you just Google sort of Head Start IP Australia, you can have a go, and there's pretty useful information on their website in terms of what to do. There's also a great tool IP Australia launched, I think it was a year and a half ago now, again, trying to help people DIY some of the trademark process. So if you've got a name for your business and you're not sure whether anyone else has a trademark, as I said, because it's not exact match, it's hard for you to kind of look up the trademark register yourself and work out whether it's free or not. This trademark checker tool was designed for people to, while they're designing their brand, or if they just want to have a quick check, you can just go on, type in your business name or product name that you want to trademark, select the classes or the industry, which is easier said than done, to be honest, and where we get a lot of questions. But if you do that, give it the name, give it the industry, IP Australia will run a quick search for you and tell you whether there are any issues or whether you're all good. So if those of you who are right now wondering whether you can trademark your name or product name, check out this website and run a quick check, and it'll pull back some results. I will say the results that it pulls back, it's pretty conservative. And so don't be too scared if you see a bunch of results. It's possible there's a way through, but if you do see a bunch of results, it's probably the case you want to chat to a lawyer just to help you work out whether it's going to be a waste of time to go ahead with this, or whether there's a clever way you can describe your trademark, pick the right industries, change what you trademark it, and kind of get it through. But yes, this is a free service, and so I'd encourage people to check it out if you want to check your trademarks. Jenny's asked, how do you find out if another company is looking to register a similar trademark so you can oppose it if needed? You can set up some notifications once you're a trademark owner with IP Australia, where they can notify you. There are services out there as well that do more thorough monitoring of your trademark for you. Big businesses pay lawyers for that service, so they will pay lawyers on retainer to conduct monthly checks. And as a business owner, it is not a bad idea yourself to conduct some checks. Because there's not only people that might be in that pending state where you might get notified that they're looking to register a trademark, but there could be people out there infringing a trademark right now. And if you're not made aware of them, they could be stealing your client base and diluting your brand. So it is something to stay cognizant of. And a lot of the trigger for us as lawyers to find out that a client has a person using their trademark is someone told them about it, or they just came across it on Instagram or online, or something like that. So there is a sort of manual monitoring process you may want to do, but for those scenarios where someone's kind of going through the process, it is possible, if you get the settings right in IP Australia, to get a digest of sort of proposed trademarks coming through as well. So what happens if someone is infringing your trademark? You find out they're using your name, they're using your logo. What do? A couple of things you can do. As I said earlier, step one is usually sending a letter of demand. Please stop using this trademark. In some cases, you can say, please stop using this trademark and you have to pay me compensation of X dollars or further action will be taken. Both are possible. You can do that if you are in the scenario. You might receive a letter like that if you are using it. As I said, it usually starts with a cease request, sometimes a monetary payment, not as common in the first letter that you would send or you'd receive, but it certainly could be. And then if they don't stop using it, you can take action. You can sue them. You can ask the court to take down their business brand name. You can sue them for damages if they're making money off your brand. You can potentially take a percentage of the money that they've earned as a business. So it can be pretty serious consequences that you can enforce on people, or could be enforced on you if you're the one infringing. But as I said earlier, the way the process normally goes down is it begins with a letter of demand and then proceeds to sort of legal action. And with small businesses, the cease and desist is usually pretty powerful. People usually stop if there's a real claim there. And really the risk or cost to them is the big rebrand, if that makes sense. So that's trademarks. Hopefully people have been suitably convinced to consider getting a trademark for their business and their products. And now let's move to copyright, the other big form of intellectual property that people would have heard of. So copyright is quite different to trademarks. Copyright is a area of law that's designed to protect creative, original works expressed in material form. So there's kind of two elements to what we just described copyright as. It's sort of creative original, there's an originality aspect, and it's expressed in material form. Famously, lawyers say there's no copyright in ideas. So if you've got a cool idea for something, that's not copyrightable. It has to be expressed in some way. It has to be written down or encoded electronically. There's got to be a manifestation of it somewhere, and that's what the copyright will protect. And the most common types of copyright are what we call as lawyers literary works, dramatic works, artistic works, and musical works. And just to give you some examples of each of those things, what we're talking about. Copyright can protect paintings, sculptures, graphics, photos, diagrams, models, sculptures. That's in artistic section. Textbooks in the literary section. Newspaper articles, blog posts, which is in this list, but a very common one. So written sort of works. Computer software is actually considered to be a literary work. Code, if you're a technology business that's written, that's original, would be copyright protected. In music, songs, film scores, or if you've got a musical jingle for your advertisement, that's copyright as well. And then dramatic works, so plays, screenplays, and so on. In addition to these four big categories, there's specific protections in copyright for actual films themselves, DVDs, recordings, and CDs or digital recordings, where these work protections protect, let's say, a song, no matter how it's used, whether it's performed as a cover or it's recorded, and so on and so forth. The other protections only protect that manifestation of that work. So if let's take an example of music. If somebody takes a song and sort of cuts up 10 seconds of it and uses it in an ad, there's actually two copyrights that are at play. One is whoever wrote the song has rights in it, and you might be infringing their trademarks by using a bit of the song they wrote. And also whoever recorded it, the producer who actually produced that version, that recording of the song, you might be infringing their sound recording copyright as well. So it's a bit of a technical point, but yeah, there's two sort of broad types of copyright that exist. So copyright's really different to trademarks in that with trademarks, I went through it earlier, there's a registration process. You submit an application, you pick an industry. In Australia, IP Australia assesses it, you wait 7 months and you find out if you've got it or not. Copyright doesn't have any of that stuff. There's no registration process for it. You automatically own it as the author the moment it's created. So if I'm strumming on my guitar and come up with a song, and the second I have finished writing that song and recorded it ideally in material form, either in some chords on a piece of paper or a music score, that ownership is owned by the songwriter. And same with a blog post. The second you complete the blog post, put that final full stop and sort of publish it, the author of that blog post owns it. It's theirs. It's their copyright. They didn't need to go to the Copyright Australia Association or whatever it is and tell anyone about it. It's owned by the author. Now, in a business context, what's really important is, you've got usually employees, contractors, people in your business who are doing all kinds of stuff that might fall into the bucket of copyright. Okay, maybe they're not writing songs, but they might be writing blog posts. They might be creating original processes or procedures for doing things. Maybe there's software code. Maybe there's photos or images for marketing purposes. All kinds of things that might attract copyright might be happening in your business done by people. Per what I just said, the default position is they own it the moment they created it. So you want to make sure that you as the business have the rights to use the stuff that was made for you. And unless there's a document somewhere that says in it, I, the author, hereby agree to assign the copyright in what I've created to X business, unless that has been signed by the author, they still own it. So it's really important. I mean, in employment agreements, there's usually a paragraph in every employment agreement called intellectual property that says, you, the employee, anything you produce in the course of employment while you're working for this business is hereby automatically transferred upon the moment of creation from you, the employee, to us, the business. So it's usually taken care of if you've got a proper employment agreement, and so you don't have to worry about employees technically owning stuff. Again, assuming you have an employment agreement. But for your contractors, for people that have built stuff for you, maybe it's your marketing agency, maybe it's your software developers, whoever it is, maybe it's your branding agency that made a whole bunch of designs and stuff for you. Those works are default owned by them, and unless they've signed a contract with you promising that you own it, it's still theirs. If they own it, whoever owns it has the exclusive right to reproduce it, to publish it, to communicate it to the public. And if you don't own it, then the author can go out and reproduce it and sell it to other people or do something similar to it. And there's not much you can do. So it is really important to make sure you got that ownership. Now, trademarks last 10 years. Copyright lasts for 70 years after the death of the author, or for the stuff that is in this other subject matter category, it's 70 years from the date of publication or creation. But it's a really, really long time. So someone creates something original and they own it for 70 years. So again, you really want to get these transfers happening, because if you don't, you're not going to have the security over those key creative assets for your business. Just to get you thinking in your business, what are we talking about with copyright? It's the software code, it's the graphic designs, it's the photos and the videos, it's the business templates and collateral. Now, if it's just like a really boring form that is very generic that you use, it's probably not original enough to attract copyright. But if you have a template of like a report that you provide your clients or something original that is meaningful and is not being used generically in the industry, your templates and any other collateral you have may tick that box. Add copy, illustrations, branding strategy documents. these are the kinds of things. So if you're looking at that list going, yeah, I got some of that stuff in my business, the second question you want to be asking is, who made it and have they transferred it to me under either an employment agreement or some other contract? Now, if you're thinking, oh man, I used a contractor to do some stuff for me, I signed something, I don't know what it said, and it's really important. You can sign something called an IP assignment deed that works retrospectively. We often do this for a lot of clients where they come to us and say, oh, I forgot to get someone to sign something. And there is a document you can use to cover things historically. But of course, they've got to agree to sign it, and they may not. So it's good to clean that up, and it's good to be thinking about this anytime you're creating new copyrightable work, just to make sure you've got a contract showing that you own it, and keeping a copy of that. Unlike with the trademark, where you get a registration number and you can prove that you own it, copyright's all offline. So your only proof that you actually own it is the contract saying from the author saying, I am the author and I agree everything I did is owned by this business. You got to keep a copy of that, and that's your proof. So again, just to be super practical about it, Sprintlaw has a folder on our Google Drive called, copyright ownership. And we have tons of contracts from anyone who's a non-employee who's built stuff for us. And we have, in fact, a spreadsheet in there, which is extra best practice showing who they were and sort of what they actually did. And that's our evidence of ownership. So that's kind of how you show you own your copyright. I kind of covered this already in terms of like ownership, but definitely be asking yourself who currently owns the key stuff. Now, the second question is not about whether you own your own business's copyright, but in your business, you may be using other people's potentially copyrightable stuff. Maybe you're making ads, maybe you're making blog posts, maybe you're posting photos made by other people, maybe you're making ads on social media. Maybe your software developers are copying and pasting bits of code from open source places. On the other end of the spectrum, you want to make sure that for copyright that you're using, you got the rights to use it. Like, have you got permission from the owner of that copyright to use it? Because if you don't, you could be infringing their copyright. And just like the trademark infringement, you can get a cease and desist and a request for them to that you have to pay them money for using their IP without your permission. So common issues we see are photos. If you're setting up blog posts or social posts and you're using photos, make sure that every photo you post, even if it's just a background image or a featured image, is one that you got the rights to use. People will be aware there's stock websites out there, royalty-free websites out there, where basically they say, here's some photos and we give you a license, a copyright license to use this however you want. Those are great photos to use. You could use them on your blogs and be secure that you got the rights to use them. You want to check the terms of the license. Some of those stock sites claim to be stock, but in the fine print, they say this is only free for personal use. If it's commercial use, you've got to pay us money. And so if you use it for your business, maybe they actually will come after you. We actually get a lot of clients with blogs get letters from photography owners who've just done a reverse Google image search and found a small business's blog using a photo they shouldn't have, and they get hit with a bill for, $300, $500. It's basically saying cease and desist or pay us this money. You've been using this for 2 years without checking with us. So again, if you know that you've used photos to promote your business, you're not sure if they're stock or royalty free, action I would say is make sure all the photos you use are in that category moving forward, and go back and check over any blog posts that you have and switch out the photos if you can to be stock or royalty free stuff that's cleared for commercial use. Otherwise, you run the risk of getting a cease and desist or potentially a request for damages. Same with your technology. Make sure your developers, if they're copying and pasting code, know that they're allowed to use that code in your software without it being a breach of someone else's rights. And same if you're cutting together marketing videos and you're using other bits of content, make sure you got the rights to do that. Now, people might be wondering, we all see on social media, Instagram, TikTok, whatever, little clips of people's video content. And you might be wondering, I've seen people post themselves dancing to Taylor Swift songs. Isn't that a copyright? And surely Taylor Swift didn't consent to everyone posting the Taylor Swift song. It's a great point, and in the early days of those platforms, artists like Taylor Swift tried to sue the platforms and sometimes individual users. I don't think Taylor Swift herself personally did this, but some big musical artists did because they said that's my copyright and you're using it without permission. Over the years, the big social platforms have entered into licensing deals with the big major labels. So oftentimes they'll block you if they don't have the license for you to use that music. They've got some automatic detection software, but it is kind of okay in many cases to post clipped up work from at least big artists and things on social media. But if it's a small artist or a photo or a video that you've just chopped up from a local person, and Instagram and TikTok don't have license deals with them, you could be infringing their copyright by posting it on social. So you just want to make sure that you're checking when you're posting stuff, you've got the rights to do so. And Instagram and TikTok often have only licenses for it to be used personally. So if you're putting together paid ads, they won't let you use that Taylor Swift song. They'll only let you use it for personal posts. So that's how that social media stuff works. People are wondering, how are people using copyrightable stuff? They've got the licenses for some stuff, but you still got to be cognizant when you are using it. So what can I do to protect my copyright? Well, first of all, tell people that this stuff is copyright protected. You don't have to do that. People have seen that C symbol all around the internet, probably. This is copyright protected. That's not a requirement to protect something. That's not a registration. That's just a conventional thing that people do to say, hey, I own this, don't use it, or I'm going to come after you. But it is a good idea to put it everywhere because it, in practice, is likely to deter people stealing your stuff. So you might not have to do it every time you use your own copyright. I mean, this presentation I'm doing right now is, my copyright, or Sprintlaw's copyright rather. I created it with one of our team members, and then under our employment agreements, it would have been transferred to Sprintlaw Pty Ltd. We haven't bothered putting a big copyright symbol on the front page of the presentation, but later on when we post it on YouTube, we will probably include a sentence saying, copyright owned by Sprintlaw. Please do not reproduce this webinar recording or presentation without our permission. And if someone did, we could cease and desist or demand action. So that gives you a sense of how it works in practice. If someone is infringing your copyright, you can, same thing, send them that letter of demand. If it's on a social platform, you can actually notify the platform and have it taken down. And again, if it proceeds beyond that, you've got those claims for damages and account of profits. Conscious that we're at time, I've got one more slide and then a few questions stacking up. I'll quickly run through this slide and maybe go for another 5 to 7 minutes or so if people want to stick around to hear the answers to those questions or ask some more questions. But if you've got some questions you want to ask, do start dropping them now and I'll cover them all in a minute. So final slide we have here is on confidential information. This is that third type of intellectual property I mentioned that is not really property in a legal sense, but is important for your business to be aware of. So we talked about trademarks that protect your identity, your brand, your logo, your key phrases, copyright that protects those creative works, your blogs, your photos, etc. What about just like great ideas or strategies or confidential info you have that if your competitors found out about it, it would not be great, but maybe it doesn't tick the boxes of being a literary or creative work, and maybe it's not a trademark, it's not your brand name. This stuff you can protect as confidential information. And what that means is, whilst it doesn't have automatic legal status as intellectual property, if you get people to sign a document saying, if you know this special stuff, you promise not to tell anyone, it is in itself a big form of protection. So certainly in your employment agreements, you will have all your employees, if you have a proper agreement, sign something saying all the stuff you learn at work is confidential. You can't share it with anyone. And if you do, you're breaking your employment contract. And certainly if you're speaking to suppliers or investors or anyone else you're going to tell some secret stuff to, you can get them to sign non-disclosure agreements, which are essentially documents that say, I'm about to tell you some secret stuff. If you share this with anyone, you're breaching this document and I could potentially sue you. So for that confidential information, if they break the contract, start telling people stuff, start sharing your secret ideas, your strategies, even your documents you might have shared with them, while you might not be able to say this is a breach of copyright, this is a breach of trademark, you can say this is a breach of that contract you signed, and you can sue them to say you promised you wouldn't share this, you got to stop sharing it, and I'm going to sue you for damages. And so again, these NDAs and these confidentiality clauses, employment agreements, can be a really third effective way to protect that secret source of your business, just by getting someone to sign these docs. And again, what you find is you may not intend to sue everybody all the time, but the act of getting someone to sign an NDA really changes behavior, and they treat information much more carefully. And it's a really good practical tool for reducing people sharing your secret stuff. So it's a good idea, I think, for most businesses to just have an NDA template. I think Sprintlaw, in our platform, we've got a free template for people that want to try generating one. Or if you want something more robust and tailored to your business, we can draft one up for you. But if you don't have one already, I'd suggest having one just to share with suppliers or other people before you share information. If you get that signed, it could be a good deterrent. So that's all the content for today's session. I'm going to run through the questions in a moment. But as I said, if anyone does want to talk more about any of this stuff, trademarks, IP, copyright, or NDAs, do feel free to book in a chat with our team, and we'd be very happy to assist. Let me just run through some of the questions we have here. First one, what sort of breach would the IP owner have? I think that was asked before I ran through the different breaches, but as just to recap, if a copyright owner is breaching is having their IP breached, someone's using their photos, their blog content, whatever it is, video content without their permission, that's called copyright infringement. The IP owner would send that cease and desist and potentially sue for damages. Pamela's asked, if you use photos of, say, food products in a cooking blog, would you be liable or would you be safe? That's an interesting question. Potentially, if you had a cooking blog and you were showing the logo or trademark inside as a photo of a brand of cheese or other ingredient, it's possible that the trademark owner could make a claim against you. Trademark law is a little nuanced in this sense. I didn't really go into this, but the trademark owner has the right to exclusively use the trademark in connection with the promotion of goods and services. So, I mean, I can say the word Apple and Cadbury. I can mention the company Apple and Cadbury in a blog post, and I'm not using it to pretend I'm Apple or Cadbury and make some money off it. I'm not using it for a commercial purpose, if that makes sense. So trademark doesn't prevent that use. You can talk about brands, you can mention brands, but if you start to use them in connection with a good or service, to imply that it's endorsed by Apple or it's endorsed by XYZ company, and then you start to enter the territory of an infringing use because you're essentially commercializing their brand. So in a cooking blog, if you're providing an ingredient list, it's very unlikely to be trademark infringement because it's an ingredient list. But if it implies in the way that the blog's presented that you are endorsed by them or associated with them or affiliated with them, then you run into a little trouble. So hopefully that makes sense. I think in general, it's probably pretty low risk and unlikely that a big brand's going to come after you for providing a recipe, for example. It actually helps promote sales of their product, so they probably want to encourage that. But you just got to be careful that you're not presenting it in a way where you're trading off their brand, if that makes sense. Another question here, I run an events business and use the photos of the event of people for marketing purposes. For me to use their photos, I verbally ask them at the event and have mentioned in TNC their photos be used. Is that enough, or do I need to protect myself more? Yeah, look, that's a really common question for event photographers or people running events businesses. I'll tell you what's best practice and then what's practical. As a lawyer, I got to say best practice is don't use any photo created by an author without having a signed document saying, like a release saying they're fine for you to use it. Because if you don't have that, there's a chance that that person can go, you sued me. You used it without my permission, and so I'm going to sue you for that purpose. If that's impractical to run around with 10 disclaimers, releases, getting everyone to sign it. At minimum, you want to get something in writing. Maybe you can get something on your phone that's like a quick release, um, uh, but there is a risk. There is a risk. And if you want to run the risk, then you're running the risk that no one ever bothers coming after you. And a lot of people run events businesses and they run that risk. But technically, they own the copyright in the photo. And until they've signed a clear document establishing that they're transferring it to you or giving you the right to use it, they've got legal rights against you. And a verbal request might be arguably, from a legal sense, like a verbal contract or whatever it is, but there'll be no evidence that they necessarily said that unless you record it somewhere. So it's risky. And then including it in your T's and C's, often the company or the business will sign the T's and C's, but the actual attendees as individuals may have never even seen the T's and C's. So I don't think you could um, enforce that against them. You need to make sure that the person who took the photos, the photographer, whether that's an individual or the photographer at the event, has agreed to whatever you're asking them to agree to. So hopefully that makes sense. But if you want to follow up on that, you can book a chat with our team and they can explain it in a bit more detail. Finally, does copyright also include the use of famous quotes on social media? That's another really interesting question. It probably depends on the quote. It obviously depends on when the famous quote is from, because if it's more than 70 years after the death of the author, we're not even in the realm of copyright. Potentially, someone makes a famous quote, that person or their estate could say that was, a performance of theirs, a performance copyright recorded in material form that's been reproduced. I'm not aware, certainly, of any small business. We've certainly never had a client who's gotten in trouble for that or gotten sued for it. Yeah, it's an interesting question. There could be something there if the quote was original enough and the author was still alive, and depending on when it was said and how it was said, I think there is a potential there. But certainly it's not something that comes up commonly. It'd be an interesting question to Google or maybe even ask ChatGPT to see what it thinks. I think that's one of those kind of fun legal questions. Would you apply the same thinking to above events question to any marketing material that you may use on your marketing channels, showing off your design work on your LinkedIn channels? Should we seek written approval first from the client? Yeah, I think the answer to that question is yes. Best practice, what big companies would do whenever they're showing portfolio work, is either in the client terms and conditions at the beginning. We do this for a lot of our marketing clients or even events clients. We have a paragraph in the T's and C's which say we can use work that we do for you, in our portfolio or on social media. Again, it's only usable against the person that signed it. So if you're using someone else's work and the T's and C's has been signed by someone different, it may not work. But if it's the client's work that you've done for them and you want to use it, you can handle it at the beginning as a paragraph in your standard terms and conditions. Or if you haven't got that signed, it's best to seek approval. And again, the best form of that is to have a simple IP license agreement. But if you can't get that or it's too cumbersome, at least something in writing from a representative of the business might be enough for what we would call like an implied IP license. So that's definitely a consideration. And again, a lot of our clients ask us this question, and we do a little bit of legal work helping them manage that process. So I would certainly encourage those of you with portfolios to think about a proper process for getting a record of the permission. Otherwise, the client could come after you for IP infringement or some other claim. Awesome. Well, we went about 10 minutes over, but to those that stuck around, I hope you found that all very useful. We do these every month. If there's topics people want to hear about, do feel free to email us and let us know. Otherwise, it's been really great to go through this and look forward to seeing you all next month. All the best.